Well, hello everyone, and welcome again once to Uncivil Law. Hope you're all having a great day. And we turn our attention today to the state's motion, or apologize, the state's response to defendant's motion to dismiss. You'll recall we covered this earlier with the Nick Rekieta motion. Nick filed a motion to dismiss and a motion to suppress, arguing in part that the evidence for the search warrant was unconstitutionally thin or improper or obtained in some way that was wrong. So there was a constitutional problem on the search warrant application, and also that his guns shouldn't have been stolen. And then also there was a suppression argument that didn't make much sense, but that's okay. That can wait for another day. As we have, of course, have been expecting, the government now of Minnesota has responded, and they're like, no, none of those things. So we're going to respond to or read the response from the state and see what we have to say on that, and we'll get started from that. So let's go ahead and read what they have to say. This was filed earlier today, about 3 hours ago, give or take, by the state of Minnesota in the county of Candy, Ohio, in relation to the state of Minnesota versus Nick Rekieta. This is state's memorandum of law in opposition to defendant's motion to dismiss. There are two issues before the court. First, where the defendant has made sufficient showing to warrant a Franks hearing. In other words, the police lied essentially on the warrant. Did they lie? Second, whether the seizure of firearms was lawful. The other argument being the suppression / confrontation issue is being deferred to another time because that makes way more sense. Based on the arguments herein, the court should deny the motions in their entirety. I tend to agree. Let's see what the state says. The United States and Minnesota constitutions provide that no warrant shall issue without showing a probable cause. Surely does say that. To determine whether a judge has a substantial basis for finding probable cause, we look to totality. And this is what I've been saying, right? This is what I've been saying the entire time, right? The issue is not whether one piece of evidence is sufficient. It's where the whole thing is evidence sufficient. It's not one thing. It's the totality of the thing. And we're trying to reach some sort of standard that we reach probable cause, which is relatively low in my estimation. I will note that Good Logic, my good friend, and yours, disagreed with me on my estimation of how low it is, but I still think it's relatively low. So if 1 out of 10 doesn't work, we could say 2 out of 10 perhaps is a better estimation. But either way, I think we're dealing with a relatively low standard. It's not very much. It's just objective evidence that there is a crime afoot, or that there's evidence of a crime that can be found in this location. So, if you want to say it's 2 out of 10, then fine. Joe was saying 5 out of 10. I think that's wrong. But, either way, that's just my opinion. So, yeah. The task of issuing judge is simply to make a practical, common sense direction whether, given all circumstances set forth in the affidavit before him, including the veracity, truthfulness, and basis of knowledge of persons supplying hearsay information. Hearsay is allowed in a search warrant application. There is a fair probability that contraband or evidence of crime will be found in a particular place. Fair probability is kind of like what we're looking at, right? So it doesn't have to be more probable than not. It doesn't have to be, more likely than not. It just has to be a fair probability. So, again, what is that exactly? But 1 out of 10, 2 out of 10 sounds right to my ear. In reviewing the sufficiency of the search warrant affidavit under the totality of circumstances test, courts must be careful not to review each component of the affidavit in isolation, which is, again, what I've been saying the entire time, right? This should sound pretty consistent with what I've been saying up to this point. The search warrant affidavit, and for that matter, by the way, in a lot of ways, although some of the nuances will change a little bit, in some ways, this is kind of what's true at the end of the game with trial. Right? The only thing we're trying to determine is what is enough, right? So at the end of the game, at, conviction, we're looking to proof beyond a reasonable doubt. But even then, you're still looking at the totality of the thing, right? And that's what juries will be told. And they'll be told that in their jury instructions, right? They'll be told how they can weigh the evidence, and they can use their common sense in weighing the evidence, and how they can weigh different pieces of evidence or even disregard pieces of evidence, right? So just because you can find a hole is not necessarily mean that you have reasonable doubt, right? So again, it's kind of like the totality. It's just the threshold you're trying to reach is obviously a lot higher. The standards you're trying to reach is a lot higher, but in some ways the totality estimation is the same. Incidentally, that would be kind of like what the Court of Appeals would be doing in the event of a conviction, right? They'd be doing the same thing. They'd be saying essentially no reasonable juror could convict. It wouldn't be enough to show a flaw in the evidence. It wouldn't be enough to show a flaw in something. It wouldn't be enough to show a reason the jury could acquit. It would be enough you'd have to show such a systemic issue that would cause the verdict to be unreliable in some way, as a typical rule. So kind of the same thing in that situation, but yeah, totality of the circumstances is kind of what you're looking for in the search warrant affidavit. CA Lothar says it's like a cop and a judge at Denny's, Kurt. You'll never know if the judge will order an arrest warrant for child abuse, drugs, weapons, and bottle possession, and if the cop would serve such search warrant. Appreciated, thank you. The Denny's joke has only become funny in the meta, but that's fine. A collection to $4.99 from People Pleaser says, potentially criminal in chat, invite them on. I love the two of you analyzing together. I can't invite them on because I'm streaming in OBS, not StreamYard. So I have no mechanism to bring him on, but I appreciate that he's here. I don't like to stream in StreamYard. I like to stream in OBS because I get more control over the audio issues, because I find audio management in StreamYard to be a complete pain in the ass. So I don't like to stream in StreamYard. So it's just me. You're stuck with me. Furthermore, the resolution of doubtful or marginal cases should be largely determined by preferences to be accorded by warrants. Appreciate. Generally, in determining whether probable cause exists, both district court and the reviewing court, and for that matter, the Court of Appeals, may only consider the information in the application for the search warrant. In other words, if you're trying to determine whether there's probable cause, you look to the thing that's in the search warrant, because it's what the judge signed off on, right? The search warrant has to have it, or not. You don't look to things outside of it, or not, right? You kind of look to what's there within its four corners, because that's what the judge signed off on. So it has to provide what you need, fair enough. But if a defendant challenges the accuracy of material facts in a facially valid search warrant, the district court is permitted to look beyond the four corners of the warrant application. So, if you're like, these are lies, then, fine. Because then if that's lies, then yeah, you can look beyond it because it has to be true, because it has to be provided under oath. Whether there was probable cause to support the warrant is decided on its face of the warrant application and information within the four corners. Yeah, again, it has to obviously be there or not. It has to provide probable cause to the judge or not. You can't go beyond that typically. To go beyond the four corners, the defendant must establish a substantial preliminary showing the affidavit contains a false material statement. We discussed that. The affiant, that is the cop, made a false statement intentionally or with reckless disregard for the truth, and the false statement is necessary for supporting a finding of probable cause. 1 and 2 will kind of merge together as a practical matter because the statement's being offered by the cop, but they kind of merge together. But yeah, basically that they lied and it matters. Yeah. The requirement of a substantial preliminary showing is not easily met. True. To make this preliminary showing, defendant must make an offer of proof in the form of a sworn affidavit of a witness. Franks is limited to cases of perjurious or recklessly false statements or omissions made by a police officer in support of a warrant. The rule does not apply to negligent misrepresentations or omissions. Further true, right? Further true. The standard is lies. For it to be a lie, it has to be knowing by definition. That's what makes something a lie, that you know that you're telling a falsehood, as opposed to just simply mistaken. So negligence is not the right standard. Intentional. And you have to show that they're lies by, affidavit. Yeah. Here, no affidavit was offered by defendant. No testimony offered by defendant or any defense witness. The only challenge to the search warrant comes from the defendant's omnibus motion, alleging the misinformation or lack of information was provided by law enforcement of the search warrant affidavit. Defendant did submit some exhibits in support of the motion. However, the exhibits are incomplete and create a misleading picture of the evidence. This is essentially a fishing expedition by defendant to go beyond the four corners of the warrant. Defendant is attempting at a Franks hearing without making the requisite showing. It doesn't sound like it's going very well over there, I have to say. This does not sound positive. The defendant argues that Kandiyohi County Health and Human Services screening out the initial child maltreatment report should have ended the inquiry for law enforcement, which doesn't make any sense because the search warrant, again, wasn't for maltreatment, so why would it be? Why would it end? The search warrant was not based solely on the maltreatment, or even primarily. Further, the screening of child maltreatment reports is controlled by an entirely different set of statutes and standards than criminal offenses. Fair. Whether there's enough to investigate child maltreatment report has no bearing on whether or not criminal activity might be occurring. That's fair too. They are different in that they do have some differences. It is possible to be maltreating a child without it being criminal, and vice versa. That is possible. Child maltreatment reports are cross-reported between law enforcement and child protection. This is a state mandate. Once Detective Pomplun received the child maltreatment report, he began an investigation of whether or not there was criminal activity relating to controlled substances, which is his prerogative. You know, the cops will investigate what crosses their imagination or fancy. They kind of have a right to go where the investigation goes. Both agencies started with the same information and provided the initial report. Applying their unique standards to that information, each agency processed it differently. It's not relevant that the child maltreatment report was screened out by Child Services. If it was relevant, whether or not child maltreatment report was screened out by an entirely different agency using a different standing has no bearing on the probable cause determination of the search warrant. The report was the basis for the start of the investigation. It was not the entire investigation. It was not the sole basis for application of the search warrant. Even if the court were to strike information about the child maltreatment report, there's still enough probable cause to search based on the subsequent investigation. Yeah, I mean, it's a piece of the puzzle. It's a piece of the puzzle, and I tend to agree. Dave says, for something to be probable, do you have to get past 50%? No. No. Probable in this context does not mean past 50%. That would mean something's more probable than not. But probable does not mean past 50%. Probable means that there is a sufficient chance of it for it to be non-trivial. And again, exactly where we draw that line is going to get tricky as different lawyers try to assess exactly what that means. I said 1 out of 10, you could say 2 out of 10, but yeah, more probable than not would be 5.1 out of 10 by definition, right? And so it's not that high, no. Probable cause is probably closest to, if you had to compare it to something, probably closest to the standard for an injunction in like a civil proceeding. Something on that order, which again is maybe of that same magnitude or even a little less than that. But yeah, it's not more probable than not. Probable does not mean more probable than not. No. Yeah, probable cause means plausible. Yeah, think plausible cause. Yeah, that's fair. Yeah, more than suspicious, less than preponderance. Yeah, you guys got the idea. Defendant also argues that defendant Pomplun intentionally misrepresented the relationship between defendant and Aaron, who has his own problems now. And I will state this unequivocally, just in case there's any problem with this. Aaron has his own problems because apparently he distributed images he wasn't allowed to distribute, and he's being charged with felonies too. And that is obviously not acceptable. So I may wind up covering that case too, because it's now distinct enough from the cases relating to Kayla in April to potentially warrant its own discussion at a later time. But, you know, if he violated the law, as far as I'm concerned, he deserves to be punished too. You know, everyone deserves the law. The law should apply to everyone. The law should apply to everyone. And if he broke the law, which it looks like he probably did, then, you know, yeah, essentially by revenge porn. He essentially by revenge porn. And it looks like he broke the law and he's being charged with a felony. Things are not going well in his corner. And, you know, my feeling on that is if he broke the law, which it looks like he probably did, then he deserves to be punished too. So, and also that would make Kayla the victim of crime, which is also unacceptable. So, you know, I feel, you know, I obviously feel bad for Kayla because she's the victim of a crime now. And so, you know, whatever else might be true, she's also now the victim of a crime, and she deserves to have justice for herself too. So, you know, I'll just say that for the record. I'm curious how they got to felony. Well, it's a felony under the relevant statute because it was being done for the purpose of harassment. Apparently, it's a felony charge. I don't understand your question. You do understand that whether something's a felony or not is not like just something arbitrary, right? So you're like, how did they get to felony revenge porn? Because it's a felony? I don't understand it. I don't understand your point. Like, different states have the right to classify it differently. It might well be a misdemeanor in some different jurisdictions. I can't speak to every jurisdiction everywhere. Apparently, the great state of Minnesota, if you're doing it for the purpose of harassing someone, considers it to be a felony. That's how they got it to be a felony, because it definitionally is. I'm very confused by that comment. It's got both felony and misdemeanor. He got both charges. Okay, fair enough. There's a misdemeanor and felony in Minnesota. Well, the state apparently feels like he meets the definition for the felony. So the state feels like they have a probable cause that he meets each and every element of the felony. So that's how they got to the felony, because they think that he meets each and every element of the charge. So that's how. I don't understand. Defendant also argues, won't Aaron just make an immunity deal? I can't speak to that. I can't speak to whether or not there will be an offer of an immunity deal. I can't speak to whether or not that's way premature. I can't speak to any of those issues. Defendant also argues Detective Pomplun intentionally misrepresented the relationship between defendant and Aaron. In the application for the search warrant, defendant Pomplun notes there's a pre-existing relationship between defendant and Imholt by referring to prior videos where they appeared together and Imholt appeared from the defendant's home. Yeah. Detective Pomplun included there may have been recently a falling out between Imholt and defendant. He also indicated that Aaron Imholt and April Imholt had separated. Detective Pomplun informed the issuing magistrate that Imholt and defendant were no longer on good terms. The full-throated threats defendant references as a memorandum all involved the idea that Imholt knows information about the defendant does not want to make public. Does not indicate something more than a falling out. Defendants state that the statements that defendant cites as threats are not threats to physical or financial harm. They're statements about sharing information defendant does not want shared. Fair. Detective Pomplun's statement that there may have been falling out between Imholt and defendant is not material misrepresentation. Defendant may disagree with it, but doesn't make it a lie. A statement indicates there's no longer an ongoing relationship. A falling out indicates the ending of the relationship was not on good terms. Even if defendant cited in his memorandum were included in probable cause, there still is probable cause. The statement cited by defendant indicates that Imholt and defendant a prior personal relationship that's no longer ongoing. This is the same information as provided. I tend to agree. Even if it could have been characterized in stronger terms, I don't think it's an out lie. Defendant Pomplun gave the issue magistrate additional information to the judge of the veracity of the statements made by Imholt. Detective Pomplun notes that Imholt had personally used controlled substances in the recent past. There are no direct statements by Imholt that the defendant was using controlled substance. Detective Pomplun pointed out that Imholt insinuated use by defendant, but not directly state that. Imholt had also talked about the video where defendant appeared to be under the influence of the controlled substance. The information provided by Imholt is not the sole basis for the search warrant, which would be really kind of dumb. Imholt's video on May 22nd, 2024 refers to the video the defendant produced on 5/21/24, where defendant appeared to be under the influence of a controlled substance. Defendant Pomplun did not rely on the statement alone. Defendant Pomplun watched defendant's video for himself. He watched the video. Defendant Pomplun has been trained as a drug recognition expert where he's received specialized training to identify signs and symptoms of someone who's under the influence of controlled substance. Based on his review, Detective Pomplun stated the defendant was showing signs of being under the influence, which sounds like enough for probable cause. to me. Defendant argues that defendant Pomplun did not watch the entire video defendant published on his social media on May 21st, 2024. In support of the contention, he submits a PowerPoint that contains a clip from the video stream. The clip is less than 1 minute long and does not include any audio. This clip was from the full video Detective Pomplun created. It was disclosed to defense on July 3rd, 2024. Defense counsel downloaded it at 12:31 p.m. on July 3rd, 2024. What was also disclosed on July 3rd, 2024, at the same time the PowerPoint clip, was the entire 4-hour and 4-minute long video from defendant's channel with audio. So the detective had the original, or at least a copy of the original. He had a full copy of the original. This was downloaded by defense counsel on July 18, 2024 at 12:49 p.m. The full video has been uploaded to the court for the court's review and shared with defendant. So in addition to the clip from Aaron's show, the officer watched the entire 4-hour original. Now, he might have watched it somewhere else, but it's a copy of the thing. So he didn't rely on Aaron's characterization. He watched the entire thing. And if you read the search warrant affidavit, he includes timestamps in the original that are correct. The defendant argues that the clip on the PowerPoint was manipulated, but as you can see from the full video stream, the clip is taken directly from the video at approximately 2 hours, 50 minutes, and 40 seconds into the video. The only editing is to cut the short clip from the entire video. The other brand on the clip may have been from application used to make the clip. The full video shows that's the entirety from the defendant's channel. There are no other labels or markings to indicate the video is not authentic. Defendant Pomplun informed the issuing magistrate that the video is no longer publicly available, but is able to view the entire video stream. The entire video is consistent with the statement made by Imholt. Detective Pomplun uses training as a drug recognition expert to describe defendant's behavior and how it's consistent with the use of a controlled substance. Makes it okay for me. It sounds okay to me. Detective Pomplun did not misrepresent the information. He viewed the entire video. This was disclosed to defendant. Defendant has had this video for over a month prior to the omnibus hearing. Instead of being candid with the court, the defendant implied the only video that was disclosed to them was the short clip. This has the appearance of an intentional misrepresentation to the court of what information has been disclosed. So the prosecution is now accusing the defense of playing dirty. Nice. Which seems fair because they disclosed exactly what they relied on as part of their disclosures, and so the defense knew. Additionally, Detective Pomplun viewed videos from defendant's channel going back several months. Between January 2024 and May 2024, Detective Pomplun notes defendant's changes in appearance, including that he's lost weight, appears tired, and overall appears strung out. All these are common with controlled substances per Detective Pomplun's specialized training as a drug recognition expert and experience as a police officer. Defendant has failed to make the requisite high showing that affiant, Detective Pomplun, intentionally made a false statement with reckless disregard. Therefore, they're not entitled to a Franks hearing. Any challenge to the search warrant is limited to the 4 corners of the document. State requests additional briefing schedule if defendant is raising general probable cause challenge to the search warrant, in addition to the Franks hearing. So they're like, no, you can't get a Franks. Franks is only if they lied, and they didn't lie. They didn't lie, and they disclosed the things, and it's good. So I tend to agree with the state on this one. I concur. The seizure of the firearms was lawful under the plain view exception. You think? Defendant's argument is grounded on the prohibition on unreasonable search and seizures found in the federal and state constitution. As a general rule, any search without a warrant is per se unreasonable unless it falls within one of few well-established exceptions. It is well established that under certain circumstances, items not named in a search warrant may be properly seized. The plain view exception to the particularity requirement of the Fourth Amendment is satisfied when or where an officer lawfully executing a search warrant authorizing the seizure of certain items inadvertently comes upon other items whose incriminating nature is immediately apparent, and also not necessarily inadvertently, by the way, because I cited that issue in a case with Joe. So even inadvertence is not necessarily required. The original case law said inadvertence, but so this is citing case laws from the 1970s. But I think it was 1990 I think it was 1990, the U.S. Supreme Court said, actually, no, inadvertence isn't actually required anymore either. So yeah, that these statements were true in 1975 is only gotten more favorable to the state since then, though. Police have probable cause to seize an object in plain view if the facts available to the officer warrant a person of reasonable caution in the belief that certain items may be useful as evidence. To justify a warrantless seizure under plain view, probable cause must be based on evidence revealed in plain view and cannot be obtained after conducting some further search of the object. It has to be in plain view. So you can't, for example, as we discussed, make any additional intrusion, no matter how slight. See, for example, Breaking Bad, when Hank Schrader showed up to the tow yard and removed the tape from the RV to see the bullet holes, and then lawyer turned junkyard owner says, yes, it must be readily apparent. That's right. It does have to be readily apparent, and you can't do any additional search. So the removing of the tape in order to reveal the bullet holes was an additional search, because only by removing the tape could he see that there were bullet holes, and that's illegal. You can't do that. It has to be apparent on its face. Yeah. So, yep, that's true. Of course, that entire thing also deals with the automobile exception, which gets into another whole territory. But let's ignore that part of the discussion for the moment and just deal with the readily apparent part and ignore how this whole search would have been probably okay under the automobile exception. But in Nick's case, we're not dealing with automobiles. We're dealing with a car, or we're dealing with a house. So we're going to press past that idiosyncrasy and move on. Was it constitutional to seize them? If it is readily apparent that that is evidence of a crime without the additional intrusive search, then yes. So as long as you can't do an additional search, but as long as it's readily apparent and obvious that it is criminal in its nature, then yes, you can seize the thing. That's fine. Slow it down a tad. Fuck you. The search warrant for defendant's home was the search for controlled substances. During that search, law enforcement located a number of firearms. The exact models and locations are listed on supplemental reports submitted by defense. The officers were acting in their legal authority to search the home pursuant to the search warrant when they located the firearms. There is no limitation in the warrant of the areas defendant's homes was not to be searched. The firearms were located under the bed of the master bedroom, in the garage, and in the safe of the garage home. Searching these locations were authorized by the initial search warrant. Fair. When law enforcement found the firearms, it was immediately apparent they were evidence of a crime. In Minnesota, it's unlawful for a user of a controlled substance to possess a firearm, also under federal law. Also located in the home was over 26 grams of cocaine, a Schedule II controlled substance, and we now have additional facts previously unknown because the lab test came back. And 8 dosage units of ketamine, a Schedule III controlled substance. There was evidence of the controlled substance use also in the home. There was evidence of the use of in the master bedroom. Law enforcement located 3 snort tubes that field tested positive for cocaine, a glass container with metal filter and grinder that tested positive for cocaine, a bag of cards and a dollar bill that field tested positive for cocaine, a digital scale that field tested positive for cocaine, a metal pan that field tested positive for cocaine, 2 metal cutters that field tested positive for cocaine, $100 bill that field tested positive for cocaine, and a cocaine scooper. I'm not 100% sure what a cocaine scooper is. Not sure if I can buy one on Amazon, but maybe I should get one and I can have a cocaine scooper too. Is that like Raisin Bran? 2 scoops? 2 scoops of raisins? You get 2 scoops of cocaine? Is that how you get? Is that part of a complete breakfast? The 2 scoops of cocaine instead of sugar? You use the 2 scoops of cocaine along with your raisin? Is that how that works? I don't know. These items are direct evidence of use in the home in addition to actual controlled substances. Also, Detective Pomplun, as a trained drug recognition expert, has own observations of the defendant from his videos that indicate him being under the influence of controlled substance, as well as the statements of individuals from Child Protection Report who indicate concerns about ongoing controlled substance use by defendant. All this information taken together shows information of controlled substance use. When law enforcement found firearms in the home, it was immediately apparent the firearms were evidence of a crime based on controlled substance. Facts. There's no further need to search the firearms. Fact. The mere possession is evidence of a crime. Facts. Making it immediately apparent that they of their evidentiary value. According, the seizure was lawful. Facts. Yeah, facts. Facts. Thus, the conclusion. Defendant's motion should be denied in their entirety. Defendant failed to make the requisite high showing that Detective Pomplun made any material misrepresentations or omissions in the application for a search warrant. Defendant's argument relies heavily on their assertion that Detective Pomplun did not view the entire video of defendant referenced in the search warrant application. Thank you, $2 from Alex Sargent, who said cocaine scooper equals snuff spoon. Okay. This argument completely overlooks the fact that the entire video was disclosed to the defendant at the same time the video clip his argument hinges on. The information provided by Detective Pomplun was accurate and no material misrepresentations or omissions were made. 10 pounds from Anime Sucks, Cope, and Sneed says, shoot your emotion in the foot by refusing to describe why Aaron hates you, because you'd have to admit Covert Gang and Aaron cuckolded you. Very high IQ defense strategies from the Baldo bunker. Fair. The seizure of the firearms is legal under plain view exception. Law enforcement was legally authorized to be in the home pursuant to the search warrant. While searching the home, firearms were located. The firearms were immediately recognized as evidence of a crime, as users of controlled substances are prohibited from possessing firearms under both state and federal law. As their evidentiary value was immediately recognized, their seizure is permitted. Signed, attorney. I agree. Yep, that sounds right to me. So, yeah. So, I mean, Nick has a couple days to respond to this, I think. And then the judge said he might take up to 30 days for a decision. But I'm reasonably confident the decision is going to be to deny the Franks hearing and deny, the probable cause. And, he might file a challenge to the thing under the basis that, there wasn't enough evidence for probable cause. But probable cause is such a low standard. If you can't get anything thrown out because it's lies, yeah. So I continue to strongly suspect that this case will not get dismissed on a challenge to the warrant. And as the drug tests appear to have come back positive for drugs, then the only other thing that could make this case any more interesting at this point is whether or not the state wants to amend the charges. Because now that they know what the other things were that they found, including these ketamine pills, they could presumably bring different charges or elevated charges or different counts. So the only way this gets any more interesting is if the state ups the ante by getting a revised charging document that potentially brings additional counts, and depending on exactly what they found, potentially even more serious counts than what they found before. So that's also possible. Jerem says, why is Nick trying to blow up the plea deal? I'm not sure that that's what's going on here. I don't think that, although I disagree with the defense counsel, obviously, this feels very normal. I don't hate the defense counsel. I don't think it's legally absurd, or at least not legally frivolous. I just don't think it works. But yeah, a plea deal is probably still the most likely result out of this, or a diversionary program of some kind is still the most likely result out of this. Plus, even if he were convicted outright of the charges that are currently on the table, and I note currently on the table, but even if he were convicted of the charges outright that are currently on the table, it is unlikely that he would ever see the inside of a jail cell. The recommended sentence disposition is something like 48 months suspended. Hypothetically, there could be jail time, but he has no prior criminal history, and there's no other reason to suspect that you're looking at really any time. So you're looking at either all suspended or some fairly minimal jail time, like in the order of 30 days maybe, or like every weekend for 2 months or whatever, or something else. But yeah, even if he was convicted outright, he's not looking at any time behind bars really, but he is looking at a felony conviction, which would obviously get my attention. So yeah. I'll answer some questions now that I've finished this. Oh, by the way, I just want to I just wanted to note that I just passed the 3,000 video upload threshold. So I suppose this makes video 3001. So thank you all for tuning in with me. It's been a journey. I'm here for it. Do I think the state views this as case as open and shut? Yes. It's incredibly normal. It's banal. This is like every day. This is every day. This is a paint by numbers case. So yes, I think the state views this as open shut. If it goes to trial, here's what's going to happen. If it goes to trial, here's what's going to happen. You're going to get the cop on the stand, and it's going to be like, yep, we went into the house, and we went into the master bedroom, and we found drugs there, and then we found drugs in their safe, and we found drugs in their bedroom, and wherever else we found drugs. And then you're going to hear from the lab tech and be like, yep, the drugs tested positive there, and here's what their weight was, and these are the drugs, and here's the lab report, and end of case, right? That's end of case. So, and then of course, you could have some additional fluff on top of it, but that's kind of like, all you really need, so, end of case. So yeah, it's very paint by numbers. I feel the state feels very, very confident going forward with their lab test confirmed, and, it's not their first time doing a drug thing. Yeah, also the guns. Also, we found some guns here nearby. Is this the gun you found? Yes, it is, Your Honor. Can you show the jury? Here's the gun. Yeah. Yeah, you got it. So, like, you need two witnesses. You need two witnesses. And then, if you want to, like, lay it on a little bit, if you want to lay it on as the state a little bit, then you bring on, April or Aaron or whoever else you have that be like, yeah, I saw him use drugs, preferably in his home would be nice. So if you have someone who can testify he used drugs in his home, who actually saw him use it in his home, would be a nice touch. So you bring on Aaron or April, or whoever it is else you have available, or concerned citizens or whoever it is to, twist the knife in, and you call it a day. Will they show the body cam footage? They very well might. Yeah, they very well might. Not for no other reason than if the house is in disarray, they'll want to see that. Then they'll want the jury to see the house in disarray. So yeah, I would imagine they would use the body cam footage in the trial. There's like, so that they can show the state of the house, and they can show the cop, reaching into the safe and pulling out the bag marked drugs. Yeah. So yeah, I imagine they bring the body cam footage in and show the house in disarray and the drugs they found and all the rest of it. Sure, of course they would. I would imagine. Could April refuse to testify? Only in so much as it implicates her Fifth Amendment rights, and it's premature for that. Same problem with Aaron, by the way. Like, Aaron obviously now has potential Fifth Amendment issues, although I'm not sure, strictly speaking, he does within the confines of testifying against him. But that's another issue for another day, whether or not he can invoke his Fifth Amendment as it relates to testifying in their case. I'm not sure how they could. he might not be able to, because the issue would be it's not relevant, whereas April's drug use is relevant. So yes, one or the other of them might be able to refuse to testify, but it's premature. It's premature because we don't know what deal they'll be offered, what deal they'll accept, or what immunity they might be given to compel their testimony. So, yeah, so it's a little premature. Could they force Kayla to testify? Probably not. Also, because Kayla is a co-defendant. Well, by the time it gets to trial, she will be. They'll be consolidated, I'd imagine. So no, they couldn't force her to testify. And even if they could, I'd have to double check on Minnesota law. But in most states, you can't be forced to testify against a spouse. In some states, you can't be forced to testify about what you hear from a spouse. And some states, you also can't be forced to testify about anything concerning your spouse. But I'm not sure which way Minnesota goes. So they might not be able to force Kayla to talk, and even with immunity, they might not be able to force her to talk because Nick might be able to stop her with marital privilege. But that depends on the specific confines of marital privilege in the state. So, but that's also premature. I thought they can't force you to testify. They can force you to testify if they give you derivative use. They can force you to testify if they give you use or derivative use immunity. So they can force you to testify as long as they promise in writing that they won't use anything you say or anything they derive from it against you, because then there's no jeopardy, right? So they can force you to testify if they give you use or derivative use immunity, or if there's no jeopardy, period, because the case has been resolved. So if April pleads out, if April pleads out, then they can force her to testify because there's no immunity, because there's no jeopardy, because she's already pled out. So it's possible. The firearms enhancement don't matter for sentencing? No. In my reading of the statute, there is no firearms enhancement to the drugs charges. There can be, but there isn't in this situation. To the best of my reading of the relevant Minnesota law, the firearms enhancements only come into play if the guns are actually used in the commission of the crime. And that's not the allegation here. The allegation is not that the guns were used in the commission of the possession. The allegation here is merely that guns were in a place. The allegation is merely that guns were possessed by them, which is not the same thing. So there does not appear to be a firearms enhancement. The guns were not used in the commission of the crime. So there does not appear to be a firearms enhancement with respect to the drug charge. No. Not as far as I can tell. What's the constitutional basis for the granting of immunity? The Fifth Amendment. The Fifth Amendment provides that no person, well, I'll read it verbatim. Give me a second. Why paraphrase when you can read? All right. No person shall be compelled in any criminal case to be a witness against himself. Well, you think about what that means, to be a witness against yourself. What exactly does that mean? And what that means is that you are providing contents of your mind, because that's what it's testimony, right? It's contents of your mind. It's from your mental recollection. And you're providing from your own mouth the words that will damn you. That's to be a witness against yourself. But if the words you say can't be used against you, then you're not being a witness, because the words can't be used against you. So the Fifth Amendment would be the basis. You're not being a witness against yourself because everything you say literally can't be used against you. So it's not brought in. So you're not a witness. Like if April, let me help you out. If April was offered use immunity, okay, and she gets on the stand, okay, and she says whatever she says that implicates her 8 different ways, right? But she only says that in the case of State versus Nick or State versus Kayla, okay? Then when it's State versus April, if that jury never hears about it, if that jury never hears it, if that jury never sees that person say those words, then they're not a witness. They never showed up. So they're not a witness because the jury never hears about it. So that's how. Does it mean you can't incriminate yourself? Does it mean you cannot incriminate yourself if you cannot plead the fifth? Well, you can only plead the fifth if you can incriminate yourself. You can only plead the fifth if you have criminal jeopardy. So you can't plead the fifth for the hell of it. You have to have some sort of criminal exposure. If Nick hid some coke in the guns, would that qualify for the enhancement? No, I don't think so. I think the guns would have to be used in a more active way in the commission of the crime under my best reading of the law. So, for example, if Nick had been busted, say, for example, at a controlled buy, okay? If Nick had been busted as a result of a controlled buy, and so, he gets the drugs, which probably aren't drugs in this situation, but whatever. He gets the drugs, and, the cops then immediately arrest him, and they arrest him for possession, and they find on his person a gun. Now you're there. Because in the performance of the purchase or acquisition of the drugs, he was using a gun or had immediate access to the gun in the commission of that offense. So the gun would have to be used in some sort of active way. If he had reached for the gun to try to shoot at the cops as they were issuing the search warrant, that would do it. Of course, that would also be other criminal offenses too. So it wouldn't just be an enhancement. But if he had picked up the gun and started, and then I started blasting, yeah, that would be an enhancement. Plus, it might trigger some other criminal penalties. Yeah. New York Renal MD for $5 says, dumb move to report Aaron for revenge porn? I don't think so. Nick, Kayla, and April are all witnesses, including hedonism evidence that generates the pics they shared. My view of this is, that Kayla is entitled to every protection of the law just as much as anyone is. And Kayla has every right and every blessing of mine to raise a criminal complaint. And if her privacy was violated, which seems apparent, if Aaron did the things he's accused of doing, which seems like he did, then, she has every right to make that complaint. And, that's fine. So that's my view of the thing. She's entitled to the protection of law just like everyone else is. And, Aaron may not necessarily be the nicest person, but, assuming the swinging allegations are accurate, I would simply ask the rhetorical question: who would have ever thought that, entering a swinging relationship might be a bad idea? And who would have ever thought that the kind of person that you might enter such a relationship with might not necessarily have the greatest possible character? Who could have ever seen that coming? ... But I digress, because she's still entitled to the full protection of the law. And she should. Just because you have bad judgment doesn't mean that you weren't a victim. So, yeah. Kayla's been naked on camera on locals. If you're referring to the camera shot, which was shot from behind when she was sitting on a dock, I really don't think that counts, and I really don't think that's fair. And even if it was fair, she chose to make that public, which is the whole thing. It was her choice. That's the whole thing. So first of all, I don't really think that counts. Second of all, even if it does count, she made the choice, which is her right. And she has the choice not to allow it, which is also her right. And her rights were violated. So I don't think that's fair. Didn't she also post that bottle pic? Yeah, but first of all, wasn't that of Nick? And second of all, same thing. If they chose to make it public, that's their decision. It's their choice. That's the whole thing about consent. It's their choice, right? Germ70 says it's sad though. Imagine your father is legally noted as a cuckold in court documents and Netflix covers it. I seriously doubt this will be a Netflix thing someday. That seems like whatever. What's the image of the bee in the hat? Will someone please type exclamation mark bee fish to inform our friends about the bee fish? Does it apply for things like posted on a paywall that have nude photos? I'm not sure exactly what the parameters of the law are, so I don't know for sure. I don't see Aaron getting convicted of anything. Whatever reputation Aaron had or Nick had is now -10. Now he's calling the cops on one person viewing his wife's pic. Well, assuming that Aaron distributed the photo and it fits the statute, then it's a crime. So like, it seems to be a crime on its face. You know, you know, you don't have to like or dislike these people, but you should try to apply the law in an even-handed manner. It's the only way to be civilized, in my humble opinion. It's like, let's try to apply the law in an even-handed manner. And like, look, if Aaron violated the law like he seems to have done, and there's video of him like sending the text message, and seems to be exactly what the police say it is, then it seems like he violated the law. And, you know, they have a colorable case. It's for the purpose of harassment. So, like, it seems to meet the definition under the statute. So, you know, therefore, it deserves to be punished accordingly by law. So, like, you know, let's just try to apply the law in an even-handed fashion. The law protects us all. The law protects us all. And so, you know, if he did the bad thing, he deserves to be punished for it. Well, if she sent it to him, doesn't matter. The redistribution is the problem. And that's revenge porn. That's what revenge porn is. If she sent it to him, but he chose to expose it beyond that, that's what the statute is designed for. So it doesn't matter. That's what the statute is. And we could read the Minnesota Supreme Court decision on the constitutionality of it, but the Supreme Court of Minnesota has said it's legal in previous iteration. We can read this real fast from this case. We'll just skim it. Minnesota Supreme Court. This is from 2020. We'll skim. We'll power read this. All right, 2016, Michael Casillas and his girlfriend were engaged in a 3-month relationship. During this period, the girlfriend gave the boyfriend access to her Dish Network account so he could watch television at work. After the relationship ended, the boyfriend used the girlfriend's login information to access her other online accounts, including her Verizon Cloud account. From the Cloud account, he obtained a photograph and video that depicted her engaged in sexual relationships with another male. The boyfriend sent the girlfriend a text messages threatening to disseminate them, whilst concealing the ID through fake email accounts and IP changers. The girlfriend told the boyfriend that sharing the video without the consent is prosecutable. Undeterred by the warning, they carried out the threat by sending it to 44 people. They're charged with a felony violation that criminalizes non-consensual dissemination. He moved to discharge the charge on constitutional grounds, alleging the statute's overbroad. Okay, and then they say blah, 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 blah. Okay. The statute provides that it's a crime to intentionally disseminate an image of another person who is depicted in a sexual act or whose intimate parts are exposed in whole or in part when the person is identifiable from the image itself, by the person depicted in the image, or by another person, or from personal information displayed in connection with the image. The actor knows or reasonably knows the person depicted in the image does not consent, and the image was obtained or created under circumstances which the actor knew or reasonably should have known the person depicted had a reasonable expectation of privacy. And this is a gross misdemeanor. Any one set of several factors can elevate to a felony. In this case, charged with felony based on intent to harass by disseminating. So that's the same statute. And then they say it covers some protected speech, and it's to do with content neutral time, place, and manner. I'm not sure that's correct, but that's what they said. And the non-consensual dissemination of private sexual images generally involves images obtained originally without consent, and images obtained with consent, usually in the context of private or confidential relationship. Once obtained, these images are subsequently distributed without consent. This dissemination is commonly referred to as revenge porn. While one's naked body is a very private part of one's person, generally only known to others by choice, non-consensual dissemination of private sexual images removes the choice from the victim. Yeah. So, based on this broad and direct threat, we find the states carried its burden of showing compelling governmental interest in criminalizing non-consensual dissemination. And then they decide whether it's narrowly tailored, and yeah, basically, so they've already decided it's constitutional, so that's fine. It's not Nick, it's his wife. Footnote 9 is funny. It's not difficult to obtain consent. Simply ask permission. We cannot imagine an emergency situation that requires immediate dissemination. Yeah, that'd be tough. That'd be tough if it's for an emergency. That'd be a tough one. Thought of privacy, once you willingly know, send a picture of someone else, that privacy kind of goes away. Not according to the statute. Again, I mean, you can just quote it back. Again, it's the redissemination. That's what it is. It's like, no, it's what it is. Just read the words, man. It's a crime to intentionally disseminate an image of another person who's depicted in a sexual act or whose intimate parts are exposed in whole or part when, among other things, the actor knows or reasonably should know the person depicted did not consented to dissemination. So if they didn't consent to dissemination, you're there. They consented to disseminate it to you, but they didn't consent to further dissemination. It was their choice. So, yeah. Could a person given immunity have a First Amendment argument for compelled speech? No, because this is in the context of testimony in court, and no, because you're only being required to observe, to say what you witnessed. So no, No, there's no compelled speech argument. We've had the ability to compel witnesses forever. The First Amendment, no, there's no First Amendment argument there. What if Aaron claims Kayla gave him consent? Well, if they did, then that would be really helpful to Aaron's case. If he had consent, then that would by its nature negate one of the elements. But Kayla says that he didn't have consent, and certainly in the prima facie arrest warrant, it doesn't seem like that's a valid line of defense. So you can always try it, but you know, that's a question of fact. It's a question of fact for the jury. Did they have consent or not? It's a question of fact. Does the statute require motive or just act? Just act. Well, just act. And then his motive or for his purpose, for the purpose of harassment, is what elevates it to the felony. So this would just be a gross misdemeanor, but the fact that he did it for the purpose of harassment is what is kicking it up to a felony. Isn't it going to be he said, she said, though, as opposed to every other court case in the history of ever? Yes, it might be. Although it'd be really helpful if he had it in writing, right? It would be really helpful if there was some email or some text that said, yeah, you can share this with other people. That'd be really, really helpful. But in the absence of that, yes, it's going to be he said, she said. And then it's a question of fact for a jury. Who do you believe? That's what juries are for. Correct. Correct. Would it matter if he's the one that took the pics? No, it doesn't. It's not in the statute. It might not be he said, she said because he'd plead the fifth, in which case he has no defense. In which case he has no defense. If he doesn't, yeah, so he could plead the fifth, but obviously then he has no defense. Because of his defense is, she gave consent, he has to take the stand. Because he's a necessary witness. The consent was given to him. So he has to take the stand. So if he doesn't take the stand, he has no defense. So that sucks. If convicted, can he still practice law? Yes. Yes. It's not exactly the first time that it's not the first time that a lawyer has been found with drugs. So yes, his license, he will not be disbarred for this. He might be suspended. He might have to go through some sort of drug treatment program. It's not the bar's first rodeo. The bar and substance abuse know each other very, very well. Jerem 70 says everyone's going to lose this if Aaron fights this in court. Aaron will be found guilty, but the whole polycule drama gets put in discovery, all public. Very well might do. That very well might do. But you know, that is what it is. I mean, all I can say is that it looks correct on the prima facie, which is all I really said for Nick in the first place. With his case, it looks correct on the prima facie. It's like, yeah, they made their prima facie. It looks correct on the prima facie. It looks right. So, you know, things don't look super positive for him. Yeah. Tam Jen says, I once heard lawyers pass the bar, they never pass another. Yeah, that reminds me of the shortest joke I ever heard. Would you like to hear the shortest joke? Would you like to hear the shortest joke I've ever heard? Okay, here it goes. An Irishman walks out of a bar. Who is Aaron? His Steel Toe Morning Show. He is the other man in their swinging relationship. But Nick still denies the swinging. Yeah, well, things are not necessarily looking super duper positive in that direction, but yeah. These type of relationships never last that long. Someone gets hurt. Yeah. Who could have ever thought this is back to my sort of like original comment. Like, who could have ever thought that, entering a swinging relationship might lead to tears? Who could have ever seen that coming? Who could have ever seen that swinging could lead to tears? Yeah. Yeah. Do I think Nick used the bottle on Aaron? No. No, no, no. No, no, no. Since part of the law is the defendant knows or reasonably should know the person depicted does not consent, does it mean a claim that they told it was fine in the past would be a good defense? Yes. Yes, they could establish consent based on a pattern of behavior. Like, we disseminate images all the time, and this is just another image, so I thought it was cool. Yeah, that would absolutely work. But of course, to do that, he has to take the stand. Because he has to, say, how he thought he had permission. Right? I thought I had permission because a text message, which he would have to authenticate, right? Or I thought I had permission because it was part of our style. We exchange text, we exchange these photos all the time. No harm, no foul. So I thought it was, that would be a potential defense. Sure. It would be a reasonable defense, potentially. Miss Mandy says, who would have thought a throuple wouldn't last? I know. The consent in the past doesn't prove consent now. But it does sometimes, or at least goes to the perception of consent in law, right? So, if there's a pattern of behavior that leaves you to believe you have consent, then it's reasonable to rely on that behavior. So, yeah, that can be a valid defense in law. That can be a valid defense. It'd be like, it's not enough that because, it's not enough. I have to say this with some nuance and some care so that I'm not misunderstood here, because this can get tricky. But it's not enough to simply say, because she said yes every time, therefore it was okay this time, right? That is enough, because obviously she could be screaming no, which obviously blows that argument apart, right? But you could say, because she says yes every time, and her behavior was consistent, because consent doesn't necessarily have to be given orally. Consent can be given through action, behavior, or some other means that indicates affirmative agreement, right? If I reach out my hand and you grab my hand, that's consent to hold hands, right? You didn't say anything, but I held up my hand, you grabbed my hand, that's consent, right? So consent can be based in word or deed, behavior. And so if, I've been dating a girl and, 9 times we've hooked up, and the 10th time is no different, there's nothing different about it, then yeah, it would be reasonable to infer consent because her behavior is indicative of that. So yes, past behavior and past conduct can be relevant to understanding consent in the mind of the parties. So hopefully I said that with enough nuance, but it's tricky, you know. It's like it's the difference between saying, like, it's not that she can't say no, it's that no has to be communicated in some way, especially when there's a pattern that indicates consent is pre-established in some sense. You know, it has to be like, you have to be on notice in some way, right? You have to know. So I don't know if that clarifies that or any way, but it can get tricky. I'm not sure I said that necessarily with the right level of nuance, but hopefully the point got clear. $2 from John Coyman. Do you think Aaron or April used a Baldo on Nick? Quite possibly. Yeah. Yeah, pushing away can be a no. Yeah, so you're looking for how was consent or lack of consent communicated, right? Because if the issue is consent, then how was consent or lack of consent communicated? You know, so pushing away, yeah, saying no, yeah, but how was it communicated in a way that would be understood? You know, so that it was clear. So the consent is as simple as T video. That's a funny video. Yeah, the consent is simple. It's funny. It's simple as T. Yeah, that's a funny video. That's a good one. It's also the state's burden to show lack of consent. Yes, because if you're arguing rape, for example, then the issue is lack of consent, and obviously, well, that has to be apparent because you want to send someone to jail for a long time, and so, you know, it has to be clear. Put if she picks up the ball and pushes closer. Could be. How does anyone ever prove Kayla didn't give consent? Well, again, it's going to come down to testimony. Assuming there is no other evidence that's available, which I don't know what the evidence is, and neither do you, but assuming there is no other evidence that's available, and there probably isn't, if I had to guess, my presumption would be there's no other evidence, then it's going to come down to he said, she said, which is not unheard of in a court case. It's literally going to be Kayla getting on the stand and saying, no, I didn't give consent. And assuming the counter argument is I did have consent, it's going to be Aaron taking the stand and say, yes, I did. And here's how I had consent. She told me it was our past behavior, blah, blah. So that's evidence. It's going to be evidence offered at trial. And it's going to be in the absence of anything to the contrary. And my expectation is that will be in the absence of something to the contrary. It's going to be he said, she said, but we do it every day. And we do it every day in court. That's what we do. We put witnesses on the stand and we ask the jury to sort it out. That's what you do. If you had a falling out, would that remove consent? Well, strictly speaking, no, because the fallout was between him and Nick that we've been talking about. If you mean the fallout between him and Kayla, that's obviously a different issue. So first of all, the fallout between him and Nick is not the same as the fallout between him and Kayla, because they're two different people, obviously. So I can't speak to the degree to which there's been a fallout and the fallout disparity with respect to those people. That's a whole nother thing. A fallout could potentially be understood as revocation of consent. It's possible. Assuming there was consent, it could be understood as revocation of consent. It's possible. If a woman gave you nudes and say, even if we break up, you can share it with whomever, then later said, I changed my mind. I don't want you sharing it. Can she do that? According to the statute, yes. She can't revoke consent for anything you've actually sent out, but she could prevent you from sending them out in the future. Yes. Yes, consent can be withdrawn. Consent can be withdrawn. Obviously, consent can't be withdrawn for anything that's already actually occurred, but it could be it can be withdrawn on a forward-looking basis. Yeah. Did Kayla ask Aaron to delete the nudes? Unclear, and that's also not relevant to the analysis. Well, it might be, because if she asked him to delete them and he didn't, that would indicate a withdrawal of consent. Withdrawal of consent, assuming consent was given, can be communicated a lot of different ways. So if she said to delete the messages or delete the things, that could be understood as a withdrawal of consent. These are very interesting questions on consent and lack of consent. It can get tricky. It can get tricky. But the sort of like, to pull it out, to pull it out. Oh, see what I did there? To pull it out a little bit, to zoom out a little bit, the issue is like, well, would a person understand that permission was given? Would a person understand permission had been withdrawn? How was that communicated? How was permission given? How was permission withdrawn? How was that communicated? So like, that's sort of the meta, right? It's like, so your questions are like, well, this do it, or this do it, or this do it. In some degree, you might be able to answer your own question. It's like, well, what do you think? Do you think that indicates, do you think that indicates the communication of intent? Do you think that indicates the communication of the withdrawal of consent? What do you think it means? And right, so it's like, how do you look at that? Can someone force you to delete any photo from your phone? No, they can't. No, but the request to do it could be understood as a withdrawal of consent of dissemination. So no, they can't. Assuming that you acquired them legally in the first place, then no. The order to the communication to delete them would not be lawful, because I have lawful possession, right? If I've taken lawful possession, you can't take that away from me. I have lawful possession now, right? But the communication of delete the messages, although it wouldn't be effective for that purpose, could be understood as also a withdrawal of consent. Assuming consent had been given, it could be understood as communication withdrawal of consent. So like, it's like, how would these things be understood by, various people? Probable cause has got to be less than the likelihood of irreparable harm for an injunction. I think that's fair. I just was trying to think of something else that made sense to compare it to. And it was like, the standard for an injunction seemed like a reasonable comparison, although I even said at the time that I think that might be a bit high. But I was just trying to think of what else could I compare it to help explain it. It's like, how do I change this thing probable cause, and how do I analogize it to something to make it a little bit more accessible? So yeah, but I think you're probably right. I think it is probably less than the standard for an injunction. Just seemed like the nearest equivalent I could think of off the top of my head. Yeah, the kids have nothing to do with the nudes, and they would be understood under different standards. Yeah, it's like, there's different laws and different standards for everything, man. It's like, you gotta understand these things under its own terms. Let's say you sent me a text message. You can't stop me from posting online as receipts. I can if the text message is revenge porn. I can. That's exactly what the statute is for. Yeah, that's exactly what the statute is for. That's what revenge porn is. Will Barnes protect Aaron's First Amendment rights? Good question. Maybe he wants to jump into that. Maybe he can represent Aaron in his case. That'd be good. So if I give pleas to consent to search my house, I can withdraw? Yes. Yes. Or your car or anything else. Yes, you can withdraw consent. Yes. If you say to the police, you have permission to search my car, and they start the search, and you're like, you know what? After all, you don't have permission to search my car. You need to stop. Yes, you can withdraw consent. Yes. You can withdraw consent to search. Yes. He has a moral obligation to read super chats. No one's stopping him from reading any super chat he wants. He's just not allowed to disseminate naked images of somebody else, which has nothing to do with reading someone else's super chat. So no. Jasmine says, thank you for reading my questions. No problem. Cops never really stop you for revoke consent. I just said that you could. And it would be legally effective if you could prove it happened. And if the cops found something after you revoked consent, you could suppress. Yeah, that's the law. That is the law. So if you give consent and the cops start to search and you're like, you know what, after all, you can't search anymore, and the cops search anyway, then yeah, that would be the basis to the motion to suppress, because you withdrew consent. They no longer had consent. So they need some other basis to continue the search. Yeah. So the cops may or may not. But that, of course, that's true whether or not you gave consent in the first place, right? The cops may search even though you didn't give consent, in which case it's a basis for a motion to suppress. So the cops may continue to search regardless of whether you gave permission or not. And then if they want to get the evidence in, they're going to need to show an exception. So yeah, I mean, that's always true. Erin wrote a bond form Erin's address, which is clearly not where she's living. First of all, I don't know how that applies as a legal matter. A person can have more than one valid address. And I don't know what the requirements are for the bond address in terms of that. I don't know what the address is. Aaron's under a restraining order not to mention his first wife on air. That seems like that's overly broad. He probably doesn't have a restraining order that he can't mention his first wife. That would be unduly broad. It's probably a bit narrower than that. Yeah, I try to thank you, Sarah. I always try to give the best legal answer I can. It's what I do. It's like I try to be a good legal educator and try to give the best legal answer and best legal analysis I can. I try really, really hard. And I have 3,000 videos and I read a lot of cases. So I try really, really hard to get the law correct and apply it as evenly and fairly as I know how to do. It's like, look, this is just what I think. This is the right legal outcome. It looks like Aaron did it bad. The evidence against Aaron looks superficially sound. It looks like he's guilty of the gross misdemeanor without breaking a sweat. It looks like he's guilty of the gross misdemeanor without breaking a sweat. The only thing that they have to prove is the harassment, and they're pretty well on their way to proving that too. So, and so he's guilty of a crime. So, bust him up. Isn't all the evidence hearsay? At the moment, yes. But that's okay. You can have hearsay. We're not in court yet. So it's okay. You can have hearsay. It's fine. Yeah. Do you like me appreciate reading some well-conceived and well-formatted legal paperwork in this case? I don't understand what you mean. The legal paperwork in this case has been fine. It's been fine. I don't understand what you mean. Hamilton says, I do a great job of calling it like I see it. Thank you. The order says he can't disparage his ex. That sounds closer. Yeah, that sounds closer. Even that seems a little bit overly broad, but that's closer than he can't mention her. Oh, he can't disparage her. Oh, that's not the same thing. But like, even that seems overly broad. It's like, but okay. If he claims Kaylee consented, then Gino and Kino's testimony is kind of worthless. Well, their testimony would be relevant insofar as it's relevant to the receipt of the images. It's a necessary element of the crime that they were transmitted to somebody else. So their testimony is worthwhile because it establishes an essential element of the crime. It establishes the essential element that it was transmitted to somebody else. So their testimony is worthwhile. Consent only consent's attacking a different part of the charge. So no, it's not worthless. How am I with information on cold murder cases? I don't understand your question. I suppose it depends on the case. I meant Nick's paperwork has been poorly formatted. Well, Nick's portion where he dealt with the motion to apparently the confrontation clause issue, which apparently that was a confrontation clause issue, which he did a really good job of hiding the ball on that. Because he spent like 4 paragraphs straight talking about Miranda, and then the last sentence talked about confrontation, and apparently I was supposed to conclude that was about confrontation. Yeah, that was not a great thing. Yeah. Aaron's first wife argued his fans used disparaging comments to harass her. Interesting. Well, I'm not going to get into the finer points of it, but I mean, fair. With the public image wasn't disclosed voluntarily. That's what we're talking about. I'm not sure what you mean. Go Tigers, you better believe it. What else can I answer for you? I've got quite a few of you on. 1,300 of you on. I'm happy to spend some time with you. We could go read the probable cause for Aaron. We haven't really done that yet. You want to read it together? We could read it. Let's read it. Let me find it. Give me a moment, please. There we go. Okay, can I make this like... Oh, okay, cool. That is the entire thing. Great. All right, so now I just need to bring in this margin a little bit. Okay. So here's the probable cause against Aaron. The complainants, otherwise known as the police, state the following facts establish probable cause. On July 17th of 2024, law enforcement took a report of an unauthorized dissemination of sexual images complaint. KR, fully identified in police reports, called in report to report Aaron sent another individual a nude photo of her without her consent. On July the 19th, 2024, KR, NR, and AI all fully identified police reports met with law enforcement. Okay, so right away, we know we're in trouble for Aaron. Right away, we know we're in trouble for Aaron. Apparently, the police said, "Hey, would you mind coming down to the station? We just have a couple questions for you." Run away! Run away! Run fast! Run hard! Run! 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 Okay. KR report over the course of several months, her, NR, and AI, and defendant communicated via the app's Signal. The purpose of the app was to keep things private among each other, and all agreed nothing would be shared with the others. KR sent a nude photograph via Signal. In April, there was a breakdown. That's the month, by the way, not the person. Lol. In April, the month, there was a breakdown and defendants started talking negatively about KR, about NR, and AI being on an online talk show. In May, he started talking negatively about KR as well. At the end of April, the month, or beginning of May, defendants started sharing details of the relationship on the talk show. Neat. On May the 27th, 2024, defendant had GB fully identified police reports on his talk show. During the show, defendant sent GB a text, which was a nude photo of KR. She did not consent to this. I've seen images or video of this moment happening. I've seen the video of it happening. It's like, yeah. Okay. NR reports that reported that the pictures were shared via Signal. In May, defendant started to talk about the relationship online. Okay. On May 27, 2024, defendant sent GB a nude photo. AI reported that there were pictures. AI, that's Aaron, reported that there were pictures shared via the Signal app. The relationship ended in April. She found out on July 12th, that defendant sent the photograph to GB on May the 27th. AI texted both GB and KT, fully identified, who both confirmed that JB received a nude photo of KR in May. AI looked at defendant's phone records, which confirmed he sent a picture of AI looked at defendant's phone records, which confirmed that he sent a picture of video to JB, which would have been on the talk show that day. Oh my God. He's actually like corroborating his own phone records to the police in person. Hold me. A review of defendant's talk show from May 27, 24 shows the defendant and GB participating. Two of them talk about KR and about her tattoos. Then defendant is seen scrolling through the phones and it looks like he's taking a screenshot and then tells GB to look at his phone. JB looks at the phone and says, "I like tattoos more than I thought." Defendant responds that, "Your boy didn't do bad, did he?" KR is then talked about in an explicit manner. Well, he might have just committed a felony, so he might have done a little bit of a bad. JB confirmed that he received a nude photograph of KR from defendant on May the 27th, 24 during the show. He described KR standing completely nude with her breasts fully exposed. He further described a tattoo under KR's left breast in the photograph. Later, law enforcement was able to confirm with KR that she did indeed have a tattoo under her left breast. GB said he deleted the photograph after. KT stated that she saw the photograph on JB's phone. JB received a text from defendant, which was a photograph of KR nude. KT described KR standing completely nude with both breasts exposed. KT said KR was identifiable in the photograph, and she knew it was KR based on the photograph. KT confirmed JB deleted the photograph. The lawyer in me is cringing so hard, I can't even tell you right now how hard the defense lawyer in me is cringing. Law enforcement spoke to defendant. He acknowledged the relationship and the use of the Signal app. However, defendant said he did not ever recall receiving or sending a note photograph of KR. He later said he did not want to definitively say he never received a nude photograph, but cannot recall being sent one. Defendant acknowledged using Signal. Defendant resides in Stearns County. Additionally, defendant studios in Stearns County, and he was in his studio when he sent the photograph. Defendant has an online talk show where he live streams multiple times a day. Leading up to the offense, and since the incident occurred, defendant oftentimes talks about KR. There you go. And or things between himself, KR, NR, and AI. Comments made during the live streams were concerning, especially in light of the incident. The state believes defendant will not stop and will continue to harass KR until and unless conditions are set, given that the state is requesting a body-only bench warrant to be issued. Complainant has reason to believe and does believe all the information is correct. Holy shit. Yeah, he talked to the police. Don't ever talk to the police, guys. Don't talk to the police. Don't ever talk to the police. Ever. Like, ever. There's no harassment, though? Getting some of the things he said on the show and stuff, I'm like, I don't know, man. With intent to harass? I don't know. Did I watch the clip? I did. Well, he might get it pled down to the misdemeanor. He might still get it pled down to the misdemeanor, so we'll see. Yeah, state gang harassment is kind of a stretch, but they might make it work. They do. They have a long way to go. Oh, but that's fine. They'll show the various statements he made on the statement, and the statements about her and the use of it and all the rest of it, and yeah. So, they're on their way. I have no problem with Rekieta talking to the police. I have no problem. I don't believe in this no snitch bullshit. I don't believe in this at all. No snitch bullshit. I don't believe in it one bit. We live in a society. We have rules in our society. We have laws. He has every right to tell the police about a crime. His wife has every right to tell the police about a crime. And I will never fault them for that. It looks like a crime has been committed against them. They have every right to make a complaint, and I hope that they obtain justice. So, that's what I think. AI is April Imholt. Oh, is she? Because it wasn't Aaron. I thought it was Aaron. But yeah, you might be right. AI might be April instead of Aaron. Fair point. They have the same initials, so fair point. AI might be April. Fair point. You have no problem with it, but Nick stated he does. Well, I'm telling you my position. So what are we talking about? It's a very strange thing. We're on my channel. I'm telling you what I think. So if you want to know what Nick thinks about it, then ask Nick. I don't know. I have no problem with it. He has. Something has gone wrong, and he should have full protection of the law. May justice be done. If the law's been broken, let him be convicted. Let justice be done. Let's live under the rule of law. It was Aaron showing the pic of Kayla to his friend. He sent it to his friend. He disseminated it without Kayla's permission, and that's a crime. That's the crime. That's the law. They're saying he's a hypocrite. Can't speak to that issue. Yeah. Maybe it shouldn't be the law. Maybe it's a bad law. The Supreme Court of the state seems to think it's legal. Which, incidentally, I think you could disagree with on First Amendment grounds. One of these days, one of these versions of these laws is going to go to the Supreme Court of the United States. I haven't picked it up yet. One day they're going to. And probably one of these laws somewhere is going to be stricken down. It's too broad. If they're not all stricken down, it's too broad, to be honest. So you could definitely criticize it from First Amendment principles. The Supreme Court of the state thinks it's okay, though. So you're obviously not going to convince them. The Supreme Court of the state thinks it's fine. But if you want to take this to the U.S. Supreme Court, you could make a reasonable case that some or potentially all of these revenge porn laws are potentially unconstitutional. It is by its nature trying to restrict content. You're trying to restrict the content. You're trying to restrict the message. You're not trying to restrict time, place, and manner. That's some bullshit. You're trying to restrict the message. You're trying to restrict the content. So that's a content-based regulation. So does it meet strict scrutiny? You could question it. So yeah, but that's not today. For the moment is the Supreme Court of the state says it's constitutional. So you got that. Hate crimes are pretty narrow though, and they're only really an enhancement. Whether they should be or not is a whole other set of issues, but they're relatively narrow in our law. Does it only apply to distributed material? Well, I think that's the statute. It says distributed. So if you only showed it, I don't think it applies. I think it says only distributed in the statute. Disseminate. Yeah, it's a crime to disseminate. So I think you can make a very reasonable argument that merely showing it is not disseminating. Yeah, I think you can make a very reasonable argument that simply showing it to somebody is not disseminating. Yeah. Do they find disseminate? At least not in this statute, they don't. But you could argue it. Could the argument be that since it's given to Aaron, it becomes his to do with what he wants? I think you make a more fundamental First Amendment argument than that, to be honest. The argument, I think, is more fundamental. It's by its nature a restriction on content. You're trying to prevent someone from sending a particular message. You're trying to prevent them from saying a particular thing. The nature of the regulation is, in its nature, content-based. So if it's content-based, which I think it is, then strict scrutiny has to apply. So the correct argument is strict scrutiny. You simply say that you either say, one, this isn't a compelling governmental interest, or two, this isn't the least restrictive means to do it. You can make the argument. You can make the argument. It'd be probably easier under some version of some state's law somewhere. Try to find the one that's like most restrictive or most overbroad and go from there. But yeah, you could definitely make the argument. You could try. So if Aaron turned his phone to the camera to see, is that disseminating? I'd say that would be disseminating, yes. I'd say that would be disseminating if you turn the phone to show on the camera, because that's now transmitting. That's transmitting. So yes, it's disseminating. Yes, I think so. By the way, if you would like to support me, may I encourage you to do so at this lovely little link down here, coffee.com/uncivillaw. You can support me either monthly or one time, and it's a lot better for me. It doesn't cost you anything more, but I get a bigger cut, so I'd appreciate it. I need money so I can buy healthcare again, would be nice. So I went to the gym today. That was good though. I did some assisted pull-up, and I did some those like ISO row with some plate row, 70 pounds on each arm row. That was a lot. That was a lot on each arm. 70 pounds on each arm. That was a lot. Holy shit. And then I did some cable delt extensions, and I did What else did I do at the gym today? Oh yes, I did some preacher curls. That was good. And something else. Is Gino also guilty? No, he didn't disseminate it. No, he didn't disseminate it, so he's fine. I have a trainer. I have an app. I use Fitbot at the moment, which I like. I'm thinking about upgrading to a virtual trainer using the app Future at $200 a month, but I want to get a little bit more under my belt first before I pay $200 a month for a trainer. But maybe someday. I have an app for the moment, and the app works fine. Tiger Rag. CLEMSON. Get an in-person real human trainer. I don't have the money. Didn't you just hear me just say just now, I need money just so I can get healthcare again? I don't have the money for an in-person trainer. Holy shit, man, come on. I don't have the money. Trainers are incredibly expensive. It's like $50 a session. I can't afford that. Are supporters precluded from retaining my legal services? No. No. Do you need a Supreme Court petition written? I'll be happy to help you with that. Am I a criminal attorney? No. My preference is civil appeals. My preference is civil. Federal civil is my preference. So if you have a federal case in civil, preferably on an appellate posture, then I'm your guy. Get a job? This is my job. I'm trying to make this succeed. Thoughts on Sarah Boone getting an attorney? Hilarious. That's why I need your support, so I can, if you want me to get a personal trainer, feel free to donate to this link. And if you can donate enough money, then I'll get a personal trainer. Will Sarah Boone get her continuance? Maybe. They're only asking for 3 weeks, maybe. $14.99 Australian. Nick Rekieta's good friend. Rolf claims there's no such thing as revenge porn. And it's all a matter of copyright. But he lives in a shack in Mexico. Am I right to be skeptical of his hollering? Yes, very much so. Very much so. He's definitely on the wrong side of the law at the moment on that one, yes. Do I have locals? No, I don't have locals. But what I do have is coffee.com. I do have coffee.com/uncivil. So you can donate through there. And that's fine. Why can't I get a well-paying job as a lawyer? I suppose I could. But I'm trying to make this channel succeed. I'm trying to make this channel work. I'm trying to make this channel become everything I need it to be. I could get a job as a lawyer. I'm trying to make the channel be successful. So I'm pouring everything I have into the channel to make it successful. That's what I'm trying to do. Ralph gets free tax super chats. He has a point. Yeah, tax-free. They might be tax-free. I don't know if anyone's ever fought the issue with the IRS, but I don't have the bankroll for that either. So if you can help support me, so that this can be, you know, everything I need to be, then it'd be helpful. Please support me at coffee.com/uncivil. All right, well, I think this chat has become exhausted and I'm tired. I'm going to sign up for now, and I will see you later. Until later, my friends, I hope all is well for my friends. Cheers now. Just for now, and goodbye.